In 1973, the Supreme Court recognized a constitutional right to abortion. In 2022, the same court said that right never existed. 49 years. Millions of women, thousands of legal challenges. One question that divided a nation. But here is what most people do not know. The woman at the center of Roe versus Wade never had an abortion. By the time the Supreme Court issued its decision, she had already given birth and given the child up for adoption. The case was moot. Her personal situation was resolved. So why did the court decide it anyway? Why did they create a constitutional framework for a plaintiff who no longer needed it? And how did that framework survive for nearly half a century before collapsing in a single opinion? This is the story of Roe versus Wade and Dobbs versus Jackson. Two cases, 49 years apart. The same question. Opposite answers. Texas, 1969. A woman identified in court filings as Jane Roe sought legal representation in Dallas. She was 21 years old, unmarried, pregnant, and she wanted an abortion. In Texas, abortion was illegal except when the mother's life was in danger. Not her health, not rape, not incest, only life-threatening circumstances. The statute had been in place since 1854. Roe did not qualify. She was healthy. The pregnancy posed no immediate threat to her life. Under Texas law, she had no legal option. She was referred to two attorneys, Linda Coffey and Sarah Weddington, both recent law school graduates, both looking for a test case to challenge state abortion restrictions. Coffey and Weddington explained the timeline. Any lawsuit would take months, possibly years. By the time a court ruled, Roe would have already given birth. The case would not resolve her immediate situation, but it could challenge the law itself. Roe agreed. The lawsuit was filed using a pseudonym to protect her identity. Her legal name was Norma McCorvey, but the case would proceed as Roe versus Wade. McCorvey gave birth in June 1970. She placed the child for adoption. The case continued without her direct involvement. Texas's abortion law was more than a century old. Passed in 1854, the statute made it a crime to procure or attempt an abortion except to save the life of the mother. Doctors who performed abortions faced prison time. By 1970, medical technology had advanced significantly. Abortion, when performed by trained professionals in controlled settings, carried lower mortality risk than childbirth. But the law had not changed. Some states had begun liberalizing their abortion statutes. California, New York, and several others allowed abortion in cases of rape, incest, severe fetal abnormality, or risk to maternal health. Texas had not moved. The law remained strict, and doctors faced criminal liability. Even in cases where an abortion might be medically advisable, physicians refused to perform the procedure. The risk of prosecution was too high. This created what lawyers call a chilling effect. Medical professionals would not provide abortions even in gray areas where the statute might have allowed them. Jane Roe's lawyers filed suit in federal court, a class action. Roe represented all women in Texas who were pregnant or might become pregnant and wanted abortions, but could not obtain them legally. The defendant was Henry Wade, District Attorney of Dallas County. His office was responsible for enforcing Texas criminal law, including the abortion statute. Wade did not write the law. He did not lobby for it. He was named as defendant because his office would prosecute violations. The case was assigned to a 3-judge panel in the Northern District of Texas, standard procedure for cases challenging state law constitutionality. The district court ruled in June 1970. The panel declared the Texas abortion law unconstitutional. but the court refused to issue an injunction preventing Wade from enforcing the law. The result was unusual. The law was unconstitutional on paper. But doctors could still be prosecuted. Nothing changed in practice. Both sides appealed. The case went to the United States Supreme Court. By the time Roe v. Wade reached the Supreme Court, the plaintiff's pregnancy had ended. She had given birth. The child had been adopted. The case was moot as to her personally. She no longer needed the relief she had requested. But the Supreme Court decided to hear the case anyway. The court applied an exception to the Mootness doctrine. Pregnancy is capable of repetition, yet evading review. By the time any abortion case reaches the Supreme Court, the pregnancy is over. If the court required an ongoing live controversy, no abortion case could ever be decided. The legal issue remained important. Other women faced the same situation. The court would resolve the constitutional question. Oral arguments were held in December 1971. Sarah Weddington argued for Roe. She focused on the woman's autonomy to make medical decisions in consultation with her physician. She emphasized the health risks of forcing women to carry unwanted pregnancies to term. Texas's attorney argued that the state had a compelling interest in protecting fetal life from conception. He characterized the fetus as a person entitled to state protection. Justice Stewart asked a question. If the fetus is a person under the 14th Amendment, then wouldn't abortion constitute homicide? And wouldn't the woman be criminally liable? Texas's attorney hesitated. He did not want to say women should be prosecuted for murder, but his argument suggested that outcome. He did not provide a clear answer. The hesitation was noted. The court did not issue a decision immediately. Instead, the justices scheduled re-argument for the following term. This was unusual. It indicated the court was divided and wanted additional briefing. Re-argument occurred in October 1972. By then, 2 new justices had joined the court, Powell and Rehnquist, both appointed by President Nixon. The same arguments were presented. The same tensions remained. Then the court deliberated. Months passed without a decision. On January 22, 1973, the court issued its opinion. 7-2. Roe prevailed. Justice Harry Blackmun wrote the majority opinion. Before joining the court, Blackmun had served as general counsel to the Mayo Clinic. He understood medical practice and hospital administration. His opinion reflected that background. Blackmun began by acknowledging the difficulty of the case. He noted the sensitive nature of the issue and the competing interests at stake. Then he addressed the legal analysis. The Constitution does not mention abortion. It does not mention privacy. The question was whether any constitutional provision protected the decision to terminate a pregnancy. Blackmun said the Constitution does protect a right to privacy. Not explicitly. But the 14th Amendment's concept of personal liberty encompasses certain intimate decisions. This interpretation relied on substantive due process, a doctrine holding that some rights are so fundamental they cannot be taken away even with fair procedures. The most relevant precedent was Griswold v. Connecticut, decided in 1965. That case struck down a law banning contraceptive use by married couples. The court found the law violated a constitutional right to privacy in marital decisions. Blackmun extended that reasoning. If married couples have a right to use contraception privately, then women have a right to decide whether to terminate a pregnancy. But the right is not absolute. The state has legitimate interests that may limit it. The state has an interest in protecting maternal health, and the state has an interest in protecting potential life. At this point, Blackmun did something unusual. He created a detailed regulatory framework. Most Supreme Court opinions decide the case and stop. Blackmun went further. He wrote what amounted to a national abortion code. He divided pregnancy into trimesters. In the first trimester, the state's interests are minimal. The decision is left to the woman and her physician. The state cannot interfere. In the second trimester, the state may regulate abortion to protect maternal health. It can require that procedures be performed in licensed facilities. It can impose safety standards, but it cannot ban abortion. In the third trimester, after viability, the state's interest in potential life becomes compelling. At that point, the state may prohibit abortion except when necessary to preserve the life or health of the mother. Viability meant the point at which the fetus could survive outside the womb. Blackmun placed this at approximately 28 weeks, though he acknowledged medical advances might change that threshold. This trimester framework was not derived from constitutional text. It was not dictated by prior precedent. Blackmun borrowed medical concepts and applied them to constitutional analysis. The opinion also addressed whether the fetus is a person under the 14th Amendment. Blackmun said no. The word person, as used in the Constitution, does not include the unborn. He pointed to other constitutional provisions that clearly applied only after birth. If the fetus were a constitutional person, the analysis would be different. The state would have a compelling interest in protecting that person from harm. But because the fetus is not a person under the 14th Amendment, Texas's law was unconstitutional. It banned abortion from conception without allowing for the woman's right in early pregnancy. The decision invalidated abortion laws in 46 states. Most states had some form of restriction. Those laws were now unenforceable under Roe's framework. States could still regulate abortion in the second trimester. They could prohibit it in the third trimester, but they could not ban it entirely. 2 justices dissented, Rehnquist and White. Justice White wrote that the court had invented a constitutional right with no foundation in text or history. He called it an exercise of raw judicial power. He argued the issue should be resolved through democratic processes, not judicial decree. Justice Rehnquist questioned whether the right to privacy, even if recognized, automatically included abortion. He noted that abortion had been regulated by states for over a century. If a constitutional right existed, why had no court identified it before 1973? He also criticized the trimester framework. It was policymaking, not constitutional interpretation. And policymaking belongs to legislatures, not courts. The dissents raised questions that would persist for decades. Is there a constitutional right to abortion? Where is it found? Who should decide such questions? But in 1973, the majority had spoken. Roe was the law. The reaction was immediate. Supporters celebrated. Women's rights organizations called it a victory for autonomy. Medical associations welcomed the legal clarity. Doctors could perform abortions in early pregnancy without criminal liability. Opponents condemned the decision. Religious groups argued that life begins at conception and that abortion ends human life. They characterized the ruling as judicial overreach. State legislatures responded. Some states that had been considering liberalization stopped. Roe had rendered the debate moot. Other states looked for ways to regulate abortion within Roe's boundaries. They could not ban it, but they could impose requirements. Parental consent for minors, waiting periods, informed consent provisions, restrictions on public funding. These regulations would be challenged in court. Over the next 49 years, the Supreme Court would hear dozens of abortion cases. Each tested the limits of Roe. The most significant challenge came in 1992, Planned Parenthood versus Casey. Pennsylvania had enacted a law requiring a 24-hour waiting period, parental consent for minors, spousal notification for married women, and certain informational disclosures. Abortion rights advocates argued these restrictions violated Roe by creating barriers to access. By 1992, the court's composition had changed. Reagan and Bush had appointed 5 justices. Many observers expected the court to overturn Roe, but 3 justices wrote a joint opinion that surprised both sides. O'Connor, Kennedy, and Souter had deliberated privately and decided that overturning Roe would damage the court's institutional legitimacy. Their opinion reaffirmed the core holding of Roe. Women have a constitutional right to choose abortion before viability. However, the joint opinion abandoned the trimester framework. O'Connor wrote that the framework was too rigid. Medical technology had advanced. Viability occurred earlier in pregnancy. The system was outdated. The court adopted a new standard: the undue burden test. States can regulate abortion before viability, as long as regulations do not impose an undue burden on access. An undue burden is a regulation that places a substantial obstacle in the path of a woman seeking abortion. The Pennsylvania law was mostly upheld. The 24-hour waiting period was constitutional. Parental consent was constitutional. Informational requirements were constitutional. Only spousal notification was struck down as creating an undue burden. Casey preserved Roe, but weakened it. The decision gave states more regulatory flexibility while maintaining some constitutional protection. For 30 more years, Roe survived. But the framework had changed, and the court's composition would change again. We're past the halfway point. If this breakdown has helped you understand how we got here, consider subscribing. These cases don't just sit in textbooks. They shape the rights you have at work, the contracts you sign, the decisions you're allowed to make about your own life. We examine one landmark case at a time. Between 1973 and 2022, 9 new justices joined the Supreme Court. Presidents from both parties made appointments that gradually shifted the court's ideological balance. By 2022, 6 justices had been appointed by Republican presidents. 3 of those appointments were made by President Trump. Mississippi enacted a law in 2018, the Gestational Age Act. It banned abortion after 15 weeks of pregnancy. No exceptions for rape or incest, only an exception for medical emergencies. 15 weeks is before viability. Under Roe and Casey, states cannot ban abortion before viability. Mississippi's law was clearly unconstitutional under existing precedent. But Mississippi was not attempting to comply with precedent. The state was challenging it. Mississippi wanted the Supreme Court to reconsider Roe. An abortion clinic in Mississippi filed suit. The case was Dobbs versus Jackson Women's Health Organization. The clinic was the only abortion provider in the state. The lower courts struck down the law. The Fifth Circuit held it was bound by Roe and Casey. The law could not stand. Mississippi petitioned the Supreme Court for review. In 2021, the court granted certiorari. The question presented was whether states can ban abortion before viability. But the underlying question was obvious. Would the court overturn Roe? Oral arguments took place in December 2021. Mississippi's attorney argued directly that Roe was wrongly decided. He said the Constitution does not mention abortion. The 14th Amendment was ratified in 1868. At that time, most states prohibited abortion. If the amendment protected abortion rights, the ratifying states were unaware of it. He also argued that Roe had proven unworkable. The trimester framework had been abandoned. The undue burden test was vague. Courts had struggled for 50 years to apply Roe consistently. The clinic's attorney defended Roe on multiple grounds. She argued that women have relied on abortion access for half a century. They have made life decisions based on that right. Education, career, family planning. She also invoked stare decisis, the principle that courts should respect established precedent. Overturning Roe would undermine public confidence in the judiciary. Justice Kavanaugh noted that the court had overturned precedent before. Brown overturned Plessy. West Coast Hotel overturned Lochner. If those reversals were correct, why couldn't the court overturn Roe? The clinic's attorney responded that those cases corrected fundamental errors. Roe was not an error. It protected a constitutional right. Justice Alito asked whether the Constitution is neutral on abortion. If so, the question should be left to democratic processes. The clinic's attorney said the Constitution protects liberty, and liberty includes intimate personal decisions. The arguments concluded. Months passed. In May 2022, a draft opinion was leaked to the press. The leak was unprecedented. Supreme Court deliberations are confidential. But someone provided Justice Alito's draft to reporters. The draft indicated the court would overturn Roe. The court launched an internal investigation. The leaker was never identified. On June 24, 2022, the court issued its final opinion. It closely resembled the leaked draft. 5 justices voted to overturn Roe. Alito wrote the majority. Thomas, Gorsuch, Kavanaugh, and Barrett joined. The opinion was direct. Roe was egregiously wrong from the start. It had no basis in constitutional text, history, or tradition. Alito reviewed the historical record. Abortion was illegal in most states when the 14th Amendment was ratified. It remained illegal in most states until Roe. This demonstrated no long-standing tradition of abortion rights. He rejected the argument that abortion rights were implicit in liberty. Liberty does not mean freedom to do anything. It means protection from specific government intrusions that violate identified constitutional guarantees. Abortion is not among those protections. He distinguished other privacy cases. Griswold involved contraception, which does not destroy potential life. Loving involved marriage, a fundamental institution with deep historical roots. Abortion is different. It terminates potential life. The state has a legitimate interest in regulating it. Alito also addressed stare decisis. He acknowledged that courts generally respect precedent, but precedent can be overturned when a decision is egregiously wrong and has caused significant negative consequences. Roe met that standard. It was wrong as a matter of constitutional law. It had generated decades of divisive litigation. It had distorted political processes. The court held that the Constitution does not confer a right to abortion. Authority to regulate abortion returns to the states. Each state may set its own policy through legislation. Chief Justice Roberts concurred in the judgment, but wrote separately. He would have upheld Mississippi's 15-week ban without overturning Roe entirely. He proposed allowing states more flexibility while preserving some constitutional baseline. Roberts was the only conservative justice who declined to join the full majority opinion. The 3 liberal justices dissented jointly. Breyer, Sotomayor, and Kagan wrote that the majority had eliminated a constitutional right relied upon for half a century. They argued the decision would force women to carry pregnancies to term against their will. Maternal mortality would increase. women's autonomy would be diminished. They also warned that the majority's reasoning threatened other rights. If abortion is not protected because it was not recognized in 1868, what about contraception, same-sex marriage, interracial marriage? The majority responded that those rights involved different constitutional questions. Dobbs addressed only abortion, but the dissent's warning raised a broader question. If the court can overturn Roe after 49 years, what other precedents are vulnerable? Roe stood for 49 years. Dobbs reversed it in one opinion, but the questions both cases tried to answer have not gone away. The law shapes your life, whether you're signing an employment contract, buying a home, starting a business, or making decisions about your own body. If you want to understand the cases that determine what rights you have and what rules govern you, subscribe. One case, 1 hour. Every week, the day Dobbs was decided, abortion laws changed across multiple states. Some states had trigger laws, statutes passed years earlier that would automatically take effect if Roe was overturned. Those laws activated immediately. Other states quickly enacted new restrictions. Within months, abortion was illegal or severely restricted in more than a dozen states. Some states moved in the opposite direction. California, New York, Illinois, and others enacted protections, ensuring abortion remained legal and accessible. The result was geographic fragmentation. Access to abortion now depends on state of residence. Women in Texas, Alabama, and Mississippi have no legal access to abortion in their home states. Women in California and New York do. This created logistical challenges. Women in restrictive states must travel. Abortion funds were established to assist with travel costs. Clinics in states where abortion is legal saw surges in out-of-state patients. Legal conflicts emerged. Some states attempted to restrict travel for abortion. Other states passed laws protecting providers who serve out-of-state patients. The issue shifted from constitutional law to interstate relations. Politically, Dobbs energized both sides. Anti-abortion organizations celebrated and began advocating for federal legislation. Abortion rights groups mobilized for state ballot measures and legislative campaigns. In several states, voters approved measures protecting abortion access, even in politically conservative regions. The 2022 midterm elections reflected this. Abortion was a significant issue for voters. Democrats performed better than many analysts had predicted. The legal question, however, was resolved. The Supreme Court had spoken. Roe was overturned. Casey was overturned. There is no longer a federal constitutional right to abortion. But Dobbs has implications beyond abortion. The opinion changed how the court evaluates unenumerated rights. Rights not explicitly listed in constitutional text. The majority relied heavily on history and tradition. If a right was not recognized when the 14th Amendment was ratified in 1868, and if it lacks deep roots in American legal tradition, it is not a constitutional right. This methodology concerns some constitutional scholars. Many rights now considered fundamental were not recognized in 1868. Women's suffrage, desegregation, interracial marriage, same-sex relationships. If constitutional rights are limited to what was accepted in 1868, other protections may be vulnerable. Justice Thomas, in a concurring opinion, argued the court should reconsider all substantive due process precedents. He named Griswold, Lawrence, and Obergefell. Contraception, same-sex intimacy, same-sex marriage. The majority said those cases were distinguishable. But the dissent questioned whether the distinction would hold. This is what Dobbs leaves unresolved. How does the court determine which liberties are fundamental when the Constitution does not list them? Is the analysis purely historical? Or do evolving understandings of liberty matter? Roe answered that question one way. Dobbs answered it differently. The question itself remains open. Norma McCorvey died in 2017. Over the years, her public statements on abortion shifted. In the 1990s, she joined the anti-abortion movement. She said she regretted her role in Roe. Then, shortly before her death, she gave an interview for a documentary. In it, she said her conversion had been financially motivated. Anti-abortion groups had paid her. Her stated opposition to abortion wasn't genuine. The documentary was released after her death. It is difficult to know what McCorvey truly believed. Her life was complex. Both sides used her story. The case bearing her pseudonym outlived her. It shaped American law for half a century, and it continues to shape legal and political debates. Dobbs did not end those debates. It shifted them from federal courts to state legislatures and ballot boxes. Some states are restricting abortion. Others are protecting it. The legal framework Roe created is gone, but the constitutional questions persist. When does life begin? Who decides? How much authority does the state have over intimate personal decisions? How much autonomy do individuals retain over their own bodies? These are not purely legal questions. They involve moral philosophy, medical ethics, and political theory. Courts attempted to answer them. Roe gave one answer. Dobbs gave another. But neither decision resolved the underlying tensions. The debate will continue in state legislatures, in elections, in ongoing litigation over state laws, and in future Supreme Court cases that test the boundaries of Dobbs. Because Dobbs did more than overturn Roe. It redefined the court's approach to unenumerated constitutional rights. That redefinition will affect cases on multiple issues for decades. Roe v. Wade was decided in 1973. It was overturned in 2022. Its legal framework is gone. But the questions it raised, and the methodology it used, will continue to shape constitutional law.